Well, hey, good afternoon, folks. Bill O'Leary here coming to you on this Thursday. We've got June 8th, 2023. And I'm going live, going to talk to you for a few minutes as part of our Thirsty Thursday series, where every Thursday I go live, generally about the same time of the day, talk about a different topic that interests me. And so if you're thirsting for knowledge, you've come to the right place. And again, topics that I talk about are topics that I see in what I do for a living. I'm an estate planning lawyer, elder law attorney, probate, and so forth. And my firm is Legacy Planning Law Group in Jacksonville, Florida. So let's go ahead and jump right in. Um, so the topic today I want to talk about is no will. Boy, are you putting your kids at risk. So many people, unfortunately, sort of delay that critical conversation or even thinking about preparing a will and confronting the possibility of your death. I get it; it's not easy. But as we have learned, let's say with the recent death, as an example of actress Anne Hesh in a car crash, not having a will can place a significant burden on your children and cause really unfortunate complications, if you will. And again, even though it may be hard to do, planning ahead is a much better solution than the alternative. So let's talk about the sort of the sad saga of Anne Hesh. This is a good example of why a person really should create a will sooner rather than later. So Hesh, for those of you that may not know, she was divorced with two children from two different relationships when she passed away in a car accident tragically. Her son, her oldest, was 20 years old when she died, and her younger son, still a minor at the time. And although they both are assumed to be sole heirs, only her oldest son is of age in order to be able to administer her estate. He now has filed for a petition, what's called for a guardian to be put in place to protect his younger brother's interest. And the guardian really is going to turn out to be a financial burden to Hesh's estate, and what ultimately is going to be available to the kids by way of inheritance, because it's going to cost money to bring a professional guardian on board. They're going to get paid for their service. So again, depleting the estate unnecessarily. Also, forcing the oldest son to have to deal with his mother's estate is really very difficult for a person to go through at such a young age, only 20 years old. Hesh's oldest son probably is not going to be able to do all of this on his own and is going to need to hire a lawyer, a probate lawyer, further increasing the costs of administration and decreasing or diminishing the ultimate inheritance going to the two boys. You know, and it's also been reported that an inventory and an appraisal of Hesh's estate is going to be needed in order to determine what it's worth, its value of the assets that she had when she died. And this process is going to require even more professional assistance and involvement, and again, more fees to just deplete the estate. And get this, some suspect that the father of the youngest child may seek to what's called intervene in the estate administration to ensure that, hey, maybe he gets a cut of the pie, or make sure that his son is treated fairly. Again, litigation costs can rack up quickly if there's any disagreement, further depleting the estate. So preparing a will and other important estate planning documents like a trust can make legal proceedings significantly less complex and expensive, and really keep your situation as private as possible. And it can also make it easier for your loved ones to know exactly what you want to your assets and where you want your possessions to go. So here's a quick question to ask yourself. Who's going to inherit if you die without a will? Do you know the answer to that? Many people don't realize that if you pass away without a will, your local state laws on what's called intestacy will determine who qualifies as your heirs and who inherits your property. So for example, if a person dies not married at the time of their death and they have children, the children will inherit everything. What if that unmarried deceased person had a long-term relationship with a partner or whatnot, or even was, let's say, engaged to be married? They may have wanted their significant other, or maybe even fiance, to inherit some of the assets, but hey, the state law is very clear. It's going to lead to a very different result. That partner or fiance is going to be cut out. Or what if you have no living children, no siblings, parents, or spouse. Your property may end up going to the government instead of friends. So having a will prevents these scenarios from happening. What about choosing a guardian for your children? That all-important guardian. So again, another benefit that parents should consider is their ability to choose a guardian for their children in advance through a will. And this especially matters when the other parent is not living or can't be located, let's say. So if a person does not set up their wishes ahead of time, multiple parties may step up after a person dies and argue over who should be responsible and take care of any minor children. A court then may be forced to make a decision, and it may not be the decision that you would want. Okay, so again, this can be an expensive, drawn-out process, court process, and traumatic for everyone involved. Whereas if you have a will and you've named a guardian in the will, I can tell you that court is going to go ahead and appoint that person unless some other reason might exist where the court should not. Bottom line, having estate planning documents in place does make your wishes more likely to be honored and does make it less likely that a court is going to have to intervene and decide what happens. And this is also true where you might be incapacitated and unable to voice your wishes. So hey, if you'd like to know just a little bit more about sort of the risk of not having a will and how that might put your kids at risk, and if you'd like to know a little bit more, we'd love to talk to you. So what we invite you to do is book a free 15-minute phone call. We like to call it our discovery call because sort of it's a chance for us to discover what's on your mind, and we can tell you if we can help you. Scheduling is very easy. Just go to our website, legacyplanninglawgroup.com. There's a button there, real clear to you. Schedule a free discovery call. Click on it, take you straight to our booking calendar. Pick the day and time that works for you. Again, that call is complimentary. If you've enjoyed this video, would ask that you like it, or better yet, would love it if you would share it. And hey, we have a YouTube channel. We keep putting up more and more video content that's being very well received, lots of views and subscribers to our channel. So we invite you to subscribe, Legacy Planning Law Group. So I'm going to give another talk next Thursday about this same time, again, part of our Thirsty Thursday series. And so if you're thirsting for knowledge, we will quench your thirst. This is Bill O'Leary. I'm going to go ahead and sign off for now. Go make it a great day and make it a better world.